I'm just going to make a point, though, as lawyers, as officers of the court, statements, you ought to at least know who your audience is when you're writing. And I'm directing this towards you, Mr. Bose. I mean, statements of judicial theft, that the judge acted outrageously, that the judge will sign anything put before him, the rope-a-dope, and finally the carnival sideshow. Terribly, terribly ineffective writing. Terrible, terrible advocacy. And I just can't leave this without pointing this out to lawyers of over 40 years and over 50 years. Anything further, justices?
I was just going to point out that starting off that this is judicial theft, which sounds like you're accusing a judge of a crime involving moral turpitude that has significant legal consequences, actually took me aback. Civil conversion is a cause of action, but to say there's judicial theft, I wasn't the trial judge. I'm the appellate judge. I'm just letting you know that that was the first thing out of the box in your appellate brief. And you should reconsider your approach to things.
Well,
attacking rulings, attacking actions, attacking evidence even, that's all fair game. But attacking the court, attacking the judge personally, and in this accusatory manner, improper. All right, your case is submitted. Lawyers, I appreciate it. Thank you very much. We are adjourned. Lisa, we can't hear you.
The 5th District Court of Appeals in Dallas, Texas is now in session. Justice Smith presiding.
Hey, good morning, everyone.
Morning.
I'm Justice Craig Smith, and joining me on the panel today is Justice Peterson and Justice Goldstein. For you who are not accustomed to these type of Zoom hearings, the procedure we use is about the same as if you were live here. We have a timing system. It's 20, 20, and 5. The appellant has up to 20 minutes to make his opening. The appellee has 20 minutes for their response, and there's a 5 minutes allocated to the appellant at the end for any rebuttal. We have this light system, as you can see. The green light stays lit for 17 minutes. Then we have the yellow light that says you have 3 minutes left. And then there's red, which means you need to have wrapped it up because your time is up. So for everybody, please turn off all your cell phones, alarms, any other devices with bells and whistles, please. If anybody has any questions as to the process, I'll take them now. All right. If not, I'm going to call case number 521-00436, Bone, aka Martin, versus Moss and Fiddlesimus, LLC. If the attorneys, before they speak, will identify themselves and name their party, I'd greatly appreciate it. And if you're ready to proceed, the appellant.
yes, Your Honor.
Mr. Bose, you may proceed.
Good morning.
Good morning.
It's good to see you all here. I have written 4 briefs in these 2 cases, and I'm still trying to get this case completely straight, which is kind of why at the beginning of my last reply brief, I quoted some dialogue from one of my favorite movies, The Philadelphia Story, where Tracy Lord, having had her self-image destroyed, says, "Oh, I'm just a mess of a girl." And see Dexter Haven, Cary Grant says back, "That's not good. That's not even conversation." And that to me is sort of what's happened in this lawsuit. It has been massively off the track of what I consider to be a legal conversation, which is we follow rules and we take evidence, which is evidence, and primarily we don't do things that violate our people's rights to due process of law when the property.
Mr. Bose, let me ask you something.
Sure.
You said you've written multiple briefs here, and we've certainly read them. who taught you that this style of writing was effective advocacy to deride and attack, not what happened in the court, in the lower court, but to attack the judge and the court itself? Who taught you that that was effective advocacy, even in a little bit?
Well, I don't know that anybody taught me. Let me tell you, as I've said in there, I've been practicing law for over a half a century, and I've
You should learn,
never.
I would have thought. I've almost been out there that long too. I've never, ever read written advocacy, a brief or a paper to a court that is as ineffective as your writing has been.
Well, I'm sorry to hear that, Your Honor.
Oh, I'm glad I haven't. I'm glad I haven't read anything like that before.
No. To me, the issues in this are very straightforward. I thought that I could share a screen. I kind of can't. And so I didn't submit the couple of documents we need to look at. Because to simplify this, because I think it's still confused, is to look at the actual documents signed by the judge. And in both cases, these.
Mr. Doris, let me ask you something. What
Sure.
you're appealing is the denial of the motion to vacate the temporary injunction against your client, Ms. Bone, AKA Ms. Martin, correct?
Yes.
And that's the sole purpose of
No. No.
okay.
The-
What else are you seeking here?
There are two cases that have been consolidated. There's an accelerated appeal on the temporary injunction, and then it's been joined with a mandamus on two turnover orders.
But those turnover orders are like 2 years old now, or a year and a half old, aren't they?
They may well be old.
And are those turnover orders? Do they name your client?
That's why I wanted to get the orders before you. The first of the turnover orders, which was issued in September of 2020. I would go to our appendix, page 90. It says that the property, we have these two channels, may be in the name of a number of people, including one of which was my client, Holly Bohm. And then the order itself goes to Google, and the Google's
Google's not in this case anymore, is it?
Well, they
It's
keep
not.
saying that
Are you telling me? Are you telling this court that Google is still in this case?
Google has always said it's a non-party. I think it is a party.
Well, you
And
can
they
think
are
what you want. We don't think they're a party. I don't think they're a party either.
Well, the problem is in their last letter to the court, they have been absolved from both of these turnover orders, and yet they are still saying we don't want to undo what those orders did, because I'm not sure quite what, but the judge has treated them extremely badly, and I think they're in fear of what he might do to them. But they, as I say, the two orders.
What jurisdiction do we have over Google right now? What can we order Google to do or not?
You can't.
Absolutely nothing.
Yeah.
Okay.
That's right. However, I would think an opinion that would have to mention their role, and that role is dependent on orders which no longer apply to them, because they're still enforcing them. They have taken away the channels, causing my client huge amounts of financial damages, and they are retaining it. And that's what we are. If those orders are vacated, then all this should come back to Ms. Bone. The first of the turnover orders listed her name in a list that it called judgment debtors and their family. And the order to Google said, turn over all these things that belong, everything you have that belongs to the judgment debtors or their family. And that's the basis on which these things were taken. However, that first order, there's no jurisdiction over Google. Google never paid any attention to it. So later, the judgment creditors decided to do something about that, and they filed a motion to compel against Google. Google said, we're not here. We have filed a restricted appearance, and you have to decide that before you decide this. The judge must cut right through that, ordered them to start doing what is said in this order. And at that point, which was a couple months after the original order, then Google took away the money out of my client's accounts and put it in the registry of the court and cut off all her access to
Is the money
accounts.
still there in the registry of the court,
Yes,
as far as you know? Okay.
yes, both. Yeah, as far as I know,
And that's almost $300,000.
that's about right.
Okay, thank you.
All right, and counsel, you are seeking to vacate both the turnover orders as well as the TI, is that correct?
That's correct.
All right. Is there any place in the record that we can look at where you have presented, because your client is now subject to the jurisdiction of the court, she's made a general appearance, is that correct?
That's correct.
Have you instituted any procedural mechanism whereby Judge Hoffman has the ability to hear an evidentiary hearing on all the allegations that you're making?
Yes.
What
We
what
filed
mechanism
motions.
was that? The motion to vacate?
Well, the first one was a motion to reconsider the temporary injunction because we weren't there. We had a hearing on it. The judge never ruled on the hearing. So thereafter, we filed a motion to vacate so that we could get before the appellate court.
Okay, so that was a May 24th hearing, is that correct? That was a motion to increase the bond, and the motion to vacate was denied at that time. It's one order.
Yes, that is correct. That is correct.
Okay, so that was your opportunity to bring evidence to that court with regard to your client's ownership of the 2 YouTube sites and all the allegations that you've made in your briefs, both at the court below and in this court. That was your opportunity to do so. Is that correct?
Yes, and there are dozens and dozens of pages of declarations and evidence, documentary evidence.
Did you offer any of that evidence in that hearing? I read the transcript. I didn't read anywhere where you called a single witness or offered any documents into evidence. Did I misunderstand the transcript?
Well, are we talking about the motion to vacate?
Yes.
Or no, because it was strictly on the documents that were filed with the court.
Were those documents ever offered into evidence?
No, but they were the basis.
So filing documents with the court does not admit them into evidence, does it?
No.
So you provided the trial court with no evidentiary basis to vacate the temporary injunction. Is that correct?
On the temporary injunction, I gave him lots and lots of sworn evidence. He never ruled on the hearing.
Did you ever seek to offer any documents into evidence in the hearing, during the hearing?
No.
Okay.
Now, with respect to the motion on to vacate the turnover orders, at that point, we had, we had a motion before the court. And in both these cases, the basis for the motion was that my client had not had the opportunity to defend herself in either of those proceedings.
But weren't
Of
both
which-
of those hearings an opportunity for your client to defend herself through
No.
the introduction of evidence or
No.
making some kind of
No.
argument?
No, she had no notice of it.
I thought you appeared in these hearings.
No, these were the hearings that turned.
I understand all that. I understand. Right.
the
I'm
original
with you. I'm with you. You things happened before your client got in the lawsuit. You are not a unique litigant in that regard. It is
I
not
understand.
uncommon for people to come in later. And you have admitted, I believe, you have acknowledged that you were given at least one opportunity to present evidence to the court to get the process to which your client is due to modify the term or vacate the turnover orders, to modify or vacate the temporary injunction hearing. And I've heard you tell me that you didn't offer any evidence in any of those hearings. Have I misunderstood you?
That's correct. However, the issue was, did she have notice of these hearings? And that was clearly a fact that nobody could deny. First of all, we have a
But all that happened
transcript
before her general appearance, correct? After she generally appeared in the lawsuit.
long before.
Right. Okay.
So how
Long
many
before.
opportunities do you think your client has in order to be able to have an evidentiary hearing? You asked for one and you got it, which would have perhaps remedied the situation. I asked you that in the very beginning.
Yeah,
Motion to vacate was an evidentiary hearing, correct?
we never got an evidentiary hearing. On the temporary injunction, we could only do that if there was a rehearing, and we were making a motion for a rehearing.
That was a motion for the reconsideration. Was your motion for rehearing?
Yeah, and it was never ruled on. We had a hearing, and the judge never ruled on it.
Are we talking about the May 24th hearing?
No. I'm not sure when that hearing was. I think it was in March.
The motion to vacate was heard in May.
Yeah.
I believe that's right.
The temporary injunction, the motion to reconsider was heard somewhere in March, as I think. Let me see.
Well, if we're
I don't
talking about
I don't think we have a complete record because I couldn't find some of the notices and from our clerk record.
I can supply you with the notice of for the hearing, and it was again. I think it was in March.
I've got 3 hearings. I've got October, and then May. Those are the only transcripts that this court has been provided.
Yeah.
Whose burden is it to present the record that we need to reverse, Mr. Dubose?
It is mine. And I think you have a sufficient record, since the fact that she was not given notice of these things is on the face of the record.
So if I understand your argument, your view is, since the turnover orders were entered before she got in the lawsuit, they must be vacated as soon as she appears in the lawsuit. Is that your argument?
No, they have to be vacated. A turnover order is not permitted to affect somebody other than a judgment debtor without a hearing. There was no hearing. Well, there's that little scrab that was made. There was no hearing at which she had the opportunity to present her argument. Similarly, at the hearing on the temporary injunction, there was evidence that she owned these channels.
What evidence was introduced? I thought you just told me you didn't introduce any evidence.
I didn't, but her husband testified, my wife owns these channels. At that point, I believe that the judge should have said, hey, she's not here, we can't go forward.
Do you believe that the judge lacked the discretion to disbelieve that testimony?
Oh, he may. I think when somebody brings up that there's a possible third party in this, that a judge has to say, hey, I cannot decide this until that issue. And continually after that, the judge says, oh, I don't know, who is going to, who this belongs to. It seems to me that to make a decision affecting a third party and their property without that party being there to present evidence, and there's piles of stuff that we have assembled that we've given to the judge.
That you've never offered into evidence.
But it's not in evidence, though.
No, it's not an evidence.
Filing it is not introducing it into evidence, Mr. Dubose.
Okay.
You have an adversary proceeding where the other side is there and you offer the evidence and they can make their objections and the trial court makes a ruling. I can attach anything to a filing. That doesn't put it in evidence. Help me understand your argument, Mr. Dubose.
Well, it seems to me that in both these cases, there is evidence that she was not present at any hearing on these issues.
Sure, we all understand and agree to that. But once she appeared generally in the lawsuit and began seeking affirmative relief, she had to do so. You had to do so consistent with the law, meaning you had to offer evidence that would demonstrate and ask for an adversary hearing. And it appears that there's been at least one hearing you were a part of that you admit you didn't call one witness or offer any evidence. And I don't understand how that's Judge Hoffman's fault.
These rulings were made, and it's clear on the hearing records of both of them that her rights were affected and she was not present. And there have been plenty of documents that have been put into the record that show that she has an interest in this property. So,
Mr. Dubose, you have anything else?
I don't think so, Your Honor.
Judges, you have any further questions of Mr. Dubose? All right. Thank you very much for giving us that minute back. For the appellee, please. Your name and who you represent, please.
Yes, Justice Smith. My name is Dan L. Wyde, W-Y-D-E. I represent the appellees Futuristichub, LLC, as well as David Tyler Moss. Both in the underlying court are judgment creditors, as well as plaintiffs, and both are appellees in these two consolidated appeals.
All right, thank you. You may proceed.
Thank you, Your Honor. While I have appeared before Justice Smith and Justice Goldstein in the past, I have not appeared before Justice Peterson, and I wanted to introduce myself and simply say, nice to meet you, sir. It's always a privilege and an honor to appear before, frankly, any judge, much less 3 justices, and for you to take time from your busy dockets to allow me or any attorney to advocate for their client. So thank you for that privilege to appear before you, because it's obviously not a right to appear. That having been said, the appellee's theme of these appeals is aid from the court. As you know, there's an underlying final judgment in this case issued by the United States District Court for the Northern District of Texas. The judgment was signed by then the United States Magistrate Paul Stickney. The federal courts don't dole out judgments like this quite very often, and it was the result of a 5-day jury trial. That judgment later abstracted in the 68th Judicial District Court, which, according to the record, if you will, there was a consolidation because the original petition, or excuse me, the application for TRO wound up in the 192nd Judicial Court. I'd like the record to reflect it. Justice Smith did not participate in any of those proceedings. The application for TRO was heard by Associate Judge McFarland. So, and then that case got merged or consolidated with where the final judgment had previously been filed in the earlier case number. And that's how all of this wound up in the 68th Judicial District Court. Appellee submitted yesterday afternoon exhibits to the bench exhibits for this, and I would like to just briefly walk you through that. And I think that will explain, quite frankly, our positions in the case and why we ask that you grant the appellee's prayers for relief.
Well, why don't you address first your ineffective service on Ms. Bone?
Ms. Bone was actually served on Ms. Bone, as you know, in the August 6 transcript, 2021 motion to vacate. I don't believe you have a complete record on the application for writ of mandamus. And that burden is on the relator, if you will, to submit a complete record because it's an original proceeding before the court. So missing from that record are the appellee's responses to his motions to vacate the injunction, as well as responses to the motion to vacate the turnover orders. Now, Mr. Dubose had an obligation under Trap Rule 52.7 to submit those responses with the accompanying exhibits, if any were admitted into evidence, or a statement that there was no evidence in the case. That was not done. So we filed, as part of our appellee's brief and prayer, we seek a motion to dismiss the petition for the writ of mandamus because you have an incomplete record under 52.7. That doesn't apply necessarily to the interlocutory appeal of the injunction. The injunction is a different proceeding, obviously, appeal under Chapter 52, I believe, of the Civil Practice and Remedies Code, an interlocutory appeal.
Mr. White, when was the temporary injunction entered?
That was entered on October 15th, 2020. And Ms. Bone.
Whoa. Are you in agreement that the 68th District Court did not have jurisdiction over Ms. Bone at that time?
No, I do not.
Okay, how did the 68th obtain jurisdiction over Ms. Bone prior to that 11/15 hearing, temporary injunction?
She was served pursuant to an order for alternative service granted by Judge Hoffman on October 13th, 2020. Ms. Bone.
October 13th or November 13th?
No, October 13th.
Okay, all right.
All right, then
Yes.
let's talk about that.
Yes.
Number one, you have alternative service. Is that correct? Under Rule
Yes.
106.
Yes, Your
And
Honor.
that is a required posting. And you would agree with me that in order to have a temporary injunction, you have to have strict compliance with the rules.
With Rule 680 through 689, Texas Rules
Right.
of Civil Procedure. Yes, Your Honor.
Okay, but that includes service on the individuals who are going to be bound by the TI. Isn't that correct?
Not entirely. Because they're
Why am
agents.
I incorrect on that?
Well, if you look at Rule 681 or 2, if I'm not mistaken, we attempted service on Mrs. Bone back in August of 2020 before she fled the country with her judgment debtor husband. Judge
I understand
Hoffman,
your characterization of this, and both of you really need to stop making characterizations that are not bound by the facts of this case. What I'm asking you specifically is this, sir. Number one, your process server says he laid the packet of information at an uninhabited house. That's one. Two, electronic email. There was no authority under the current rules until December of 2020 for electronic service, unless they're subject to another rule, whether it's standing order or some other rule that you haven't pointed me to. Two, the affidavit had the missing L for Gmail on her service. So what evidence do you have that you effectuated service under alternative service that was effective?
the process server filed his return of service, if you will, via email, and she was served at numerous email addresses, which had been
What
authorized.
authority did you have to serve her via email under the rule?
The district court has the authority to allow service by other alternative means, if you will. And because they had fled the country, we knew this because the husband had already appeared. He had already admitted that he had moved at Clacton-on-Sea in England with his wife. And in fact, he confirmed that in the October 15th hearing.
I won't even start with you on the Hague Convention of Service, but as far as the email service is concerned, the Texas legislature authorized the Texas Supreme Court to come up with rules for electronic service. Are you aware of that?
Yes,
And you're aware that Rule 106 was amended to provide for electronic service. Is that correct?
yes,
And you're aware that that rule took effect in December of 2020. Is that correct?
yes,
And you would agree with me that the service upon Ms. Bone via electronic communication or electronic email was prior to the effective date of Rule 106 authorizing service by electronic communication.
yes.
So what authority did the district court have? Was there a standing order due to COVID that allowed for it? I just don't see it in the record.
If one of the 45 Supreme Court orders previously, Texas Supreme Court orders authorized it, I cannot quote to you which one, but I do believe the trial court has discretion to fashion when it comes to alternative service. It's not just the method of the service, it's the purpose of the service, which is obviously notice and due process. And I believe Judge Hoffman has the authority to fashion the discretion to allow for alternative service, which he did and which was expressly requested after we supplied him with numerous email addresses that her husband, the judgment debtor, and she were using. And in fact, later in November, when at a turnover hearing, we produced evidence that the appellate, Ms. Bone, was using the exact same email addresses that we served her at in October prior to the temporary injunction to sell a house in Frisco, Texas to
For which you've got a collection, you've got a quiet title on that as well. I mean, you've got several different collection actions going. You have the turnover action,
yes, ma'am.
you know, which I thought was fascinating, just as an aside, that it basically the turnover was to you.
Well, yes, because frankly, I'm sorry.
To Levy. I've never really seen a turnover order that gave property to an attorney.
Well, we asked, obviously, the judge said no, and I think that was a mistake on our part. It should have been turned over to the registry of the court and on a turnover. Now, we obviously with garnishments and levies and executions, it depends, but the property can be turned over to the sheriff or the constable for sale or to whomever the court authorizes in its writ of levy or writ of execution. I think it kind of depends on the nature of the property. May I direct you back to my exhibits that I've provided to you in the bench, if you will, and continue briefly. Thank you. So if you will, exhibit number 1 is a Secretary of State's document that shows in the clerk's record, CR 21-24 and the reporter's record, volume 2, page 710 of the temporary injunction hearing, if you will, showing that Futuristichub, which is non-exempt intellectual property, it's non-exempt property under Chapter 42 of the Texas Property Code, and therefore can be executed upon. That company, LLC, was formed after the final judgment in the United States District Court to shield that property from the judgment creditors. Ultimately, because the old underlying judgment was never supersedious or superseded, if you will, with a bond or any attempt to stay collection. That document shows that the judgment debtor, Brian Martin, and his then wife, Chrissy Martin, formed this LLC, Futuristichub. Next, exhibit 2 shows December 2018 and December 2019 payments to the judgment debtor, Brian Martin, in the amount of approximately $185,000 for 2 months of Google AdSense revenue from these YouTube video channels. Why would the money go to Brian Martin if these channels were owned by Holly Bone? The answer is they were not owned by Holly Bone. Of course, Judge Hoffman has seen all this evidence, if you will, prior to any of these motions to vacate temporary injunction or turnover orders in the spring and summer of this year. Exhibit number 3, if you will, is the final decree of divorce wherein Emily Miskell, the sitting family district judge in Collin County, specifically awarded this Futuristichub and all of these YouTube channel property, if you will, to Brian Martin in a final decree. Now, Judge Miskell can't give Brian Martin property that belongs to somebody else, separate property, and he certainly wasn't married at that time. That would have made him a bigamist, if you will. And so, and of course, Holly Bone never intercedes or intervenes in any divorce to say that's my property. And yet 90 days later, and that's, the final decree of divorce where Judge Miskell awards this property pursuant to our obligation, our burden to trace the property we're attempting to execute on, is volume 2 of the reporter's record, pages 7 and 11, plaintiff's exhibit 5. That's the final decree of divorce.
All right, so when was the date of the divorce?
The divorce was in March of 2019.
Okay, so this is my question to you. They incorporated this on June 7th of 2016, and we're arguing the merits, and I was more concerned with whether or not you ever had jurisdiction over Holly Bone, but you've answered my questions, and I've got the record. But it was involuntarily terminated on June 19, 2017. Is that correct?
I believe so.
So that corporation doesn't exist as a corporate entity at the time of the divorce where Judge Miskell awarded it to Mr. Martin. Is that correct? Or am I missing part of the record?
Well, it becomes a sole proprietorship at that point in time, and she awards him all interest, if you will, in that business. If you look at the final decree of divorce, she awards him all interest.
No, I understand. I was just, it's an involuntary termination of the LLC. So
Yes.
You're saying that, okay.
Yes, Your Honor.
All right.
And the record speaks for itself. So if I obviously misspeak or make some, I defer to the record. I mean, that's a record from the Secretary of State's office.
It's voluminous. It's been a slog fest to go through it. Yes.
Well, I didn't throw the party. I apologize. I was just invited later, if you will. So as far as the appeals go, sorry about that.
No, but you started the party, so.
Yeah, well, I did. Well, yes, we did. I've been to that back in 2014.
Multiple levels.
Now, on exhibit number 5, Your Honor, and other justices, you'll see the motion to vacate the TO orders. That's supplemental reporter's record, volume 1 of 1. And in this record, which is probably the best evidence I have, if you will, in this case, Judge Hoffman opines. He opines that Holly Bone is not innocent. That's on page 11 through 15. He opines that she, and that he goes through and explains, if you will bear with me, I know I don't want to read, so to speak, to you, but he says it's very suspicious that the judgment debtor's wife all of a sudden owns all these properties. That's page 13 of the August 6th motion to vacate, which was denied. Then on the next page, Mr. Dubose, I would just ask your client to have her husband participate. Well, he has now a partial default judgment against him because his pleadings have been stricken, death penalty, because of his complete and total failure to participate. Judge Hoffman opines he fled the country. Now he says that, okay? We've argued it, but Judge Hoffman obviously is allowed, as all of you know, or two of you as at least trial judges, and certainly Judge Peterson knows this, that a judge is allowed to form opinions in a case. They just can't come from an extrajudicial source. And of course, this happens all the time. And Mr. Dubose immediately filed a motion to recuse after this hearing was provided. And the first administrative judge, Judge Wheelis, actually denied that without any hearing and without any briefs or any of that nature, because it was deficient on its face. Next page, if you will, or on that same page, Judge Hoffman opines that Holly Bone is not an innocent victim. Brian Martin was 35 years old, divorced for 2 months, and goes and marries this 20-year-old. And with all due respect, you know, she may be, obviously she's a kid. I mean, let's just be honest with it. She's 21 years old, but she fled the country, and in the divorce petition and proceedings that occurred in Collin County, she was aware of this judgment against her husband. In the record, you will find emails that we included in the appendix to our brief, I believe, that In 2019, after we were serving subpoenas on Google, trying to find out the extent of the property that we could levy on, she's emailing me, telling me that she owns this property. Now, all of this makes her an insider by definition under the Texas Uniform Fraudulent Transfer Act, because she is like
When did she email you, Mr. White?
May of 2019.
Did you attempt to serve her or bring her in as a party at that time?
We had no idea at that time who she was. We thought she was actually originally a niece of Brian Martin. We didn't know who she was. We'd never heard of her before. In fact, we thought the emails were fake.
But she's claiming ownership, right?
Well, she's claiming it, but Judge Hoffman is opined that he doesn't believe she's the
That wasn't my
owner.
question. Did Judge Hoffman at the time of the TI see those emails? Or did you reveal those emails to Judge Hoffman of this 2019 claim of Ms. Bone that she owned it?
No, because
Probably
no,
not.
no,
Probably
because
not.
she had avoided service. She left the country and
No,
failed.
but you understand jurisdiction, you understand due process, you understand service, and this woman was not before the court.
Respectfully, I understand that concern. We
I
disagree.
have a lot of problems with this mode of service or notice, especially when a process server leaves paperwork at an abandoned house.
Well,
That's
it was
not effective service.
It wasn't, at that time, we did not know anything about abandoned. It had furniture. And in fact, that's where they were making the videos. Now, when they flee the country, they have unclean hands. When you avoid service and all of the mail that was sent to that address at 12452 Cajun Drive, Frisco, Texas, okay, all of that mail has been returned unclaimed and, if you will, they have unclean hands, and under Civil Practice and Remedies Code, Section 30, they have to provide an address to the court.
We're not there. I'm not there with you on this, but these are temporary orders, correct? No matter,
Yes,
does the court have a hearing set for a final judgment or
Yes.
a permanent injunction? When is that set?
that is set, I believe, in April of 2022.
Okay.
May I have any additional time simply to answer any questions you have?
If they have it, the justices, do you have any further questions? Okay. Hey, Mr. White, thank you very much.
Pleasure to be before you. Thank you.
Good to see you. Mr. DeBose, you're on mute. You got 5 minutes. Mr. DeBose.
Yes, just a few short points. There's no return of service that says that she was served by email. There's a very strange little piece of paper that's unauthenticated. The only document we have from the process server is the one that was left at her house. And again, the LLC never had any, there's no evidence that the LLC, Futuristichub, actually had or got money from the channel. And it's also in the record very clear about this, that up until 2019, Mr. Martin was managing the channel. So he had control over everything. And he would giving you some background on what a manager is and what an actual owner is.
But your brief gave us a lot of description about this, but okay, you have the authorized person's return affidavit of service under Texas Rules of Procedure 106 court order. That's on file.
Right. And
Okay.
there's nothing else.
And the evidence that you're talking about is evidence that's in your hands. Is that correct?
Which?
The Futuristichub issues, the Holly Bone ownership from prior to her marriage with Mr. Martin. Is that correct?
That they have been talked about extensively in the declarations of
The
Mr.
evidence
Martin
is
and
before,
Mr.
but you have not presented that evidence to the court in a manner in which anything can be done.
Well, I think the judge could have ruled on those things, but they weren't entered into evidence. But they were obviously critical to his decisions. And then again, there's no the LLC's expired, never never did anything in it. The divorce action, a divorce petition cannot determine the rights of third parties. So that got put in there, but it is apparent that, Mr. Martin, in his testimony said that's what he did. Is he managed channels. That's the way he made his living. And her channel was one that he managed. There's evidence of money that came in. There's no evidence about what that money was for. He got the money. Who knows where it came? Who knows where it went? Yeah, I think that's it. Thank you, Your Honor.
Justices, yeah. Okay. Listen, I appreciate the presentation. I'm just going to make a point, though, as lawyers, as officers of the court, statements, you ought to at least know who your audience is when you're writing. And I'm directing this towards you, Mr. Bose. I mean, statements of judicial theft, that the judge acted outrageously, that the judge will sign anything put before him, the rope-a-dope, and finally the carnival sideshow. Terribly, terribly ineffective writing. Terrible, terrible advocacy. And I just can't leave this without pointing this out to lawyers of over 40 years and over 50 years. Anything further, justices?
I was just going to point out that starting off that this is judicial theft, which sounds like you're accusing a judge of a crime involving moral turpitude that has significant legal consequences, actually took me aback. Civil conversion is a cause of action, but to say there's judicial theft, I wasn't the trial judge. I'm the appellate judge. I'm just letting you know that that was the first thing out of the box in your appellate brief. And you should reconsider your approach to things.
Well,
attacking rulings, attacking actions, attacking evidence even, that's all fair game. But attacking the court, attacking the judge personally, and in this accusatory manner, improper. All right, your case is submitted. Lawyers, I appreciate it. Thank you very much. We are adjourned.